Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and ring the notification bell so you can be updated every time we upload new content. It's our aim to upload new content every day at 8 a.m. Eastern Standard Time. Question number 1. Adam owns Town Acres in fee simple, and Bess owns the adjoining Green Acres in fee simple as well. Adam has kept the lawns and trees on Town Acres trimmed and neat. Bess, however, lets nature take its course at Green Acres. The result is Green Acres is a tangle of underbush, fallen trees, and standing trees that are in danger of losing limbs. Many of the trees on Green Acres are near Town Acres. In the past, debris and limbs have been blown from Green Acres onto Town Acres. By local standards, Green Acres is an eyesore that depresses market values of real estate in the vicinity, but the condition of Green Acres violates no applicable law or ordinances. Adam demanded that Bess keep the trees near Town Acres trimmed. Bess refused. Adam brought an appropriate action against Bess to require Bess to abate what Adam alleges to be a nuisance. In the lawsuit, the only issue is whether the condition of Green Acres constitutes a nuisance. The strongest argument that Adam can present is that the condition of Green Acres, A, has an adverse impact on real estate values, B, poses a danger to the occupants of Town Acres, C, violates community aesthetic standards, or D, cannot otherwise be challenged under any law or ordinance. Choose wisely. You have 10 seconds. If you chose A, has an adverse impact on the real estate values, you'd be correct. A private nuisance is an unreasonable interference with the plaintiff's use and enjoyment of their land. The interference must be substantial and unreasonable. The defendant's conduct is unreasonable if the harm to plaintiff outweighs the utility of the defendant's conduct, or the harm caused to the plaintiff is greater than the plaintiff should be required to bear without compensation. The defendant's conduct must also be negligent, abnormally dangerous, or intentional. In this case, Bess lets nature take its course at Green Acres. This could be considered negligent interference with Town Acres, although it may have become intentional interference when Bess refused to keep the trees near Town Acres trimmed after Adam demanded she do so. If Adam shows the debris and large limbs that blow from Green Acres onto Town Acres and shows that it creates a danger to Town Acres occupants, then this interference is likely substantial. It is also likely that the harm posed to Adam by this debris and large limbs is greater than whatever utility Bess has in letting nature take its course. Accordingly, the strongest argument that Adam can present is that the condition of Green Acres poses a danger to the occupants of Town Acres. Let's move on to question number 2. Smart approached Johnson and inquired about hiring someone to kill his girlfriend's parents. Unknown to Smart, Johnson was an undercover police officer who pretended to agree to handle the job and secretly taped subsequent conversations with Smart concerning plans and payment. A few days before the payment was due, Smart changed his mind and called the plan off. Nevertheless, Smart was charged with solicitation to commit murder. Smart should be A, acquitted because he withdrew before payment and commission of the act, B, acquitted because no substantial acts were performed, C, convicted because the offense was completed before his attempt to withdraw, or D, convicted because Johnson agreed to commit the offense. Take 10 seconds and choose your answer now. If you chose option C, convicted because the offense was completed before his attempt to withdraw, you'd be correct. Solicitation is inciting, urging, counseling, or commanding another to commit a crime with the specific intent that the person solicited commit that crime. A solicitor who solicits and then withdraws remains guilty for the solicitation but avoids accomplice liability. In this case, Smart solicited Johnson to kill his girlfriend's parents. Withdrawal is not a defense for solicitation. Thus, on the charge of solicitation to commit murder, Smart should be convicted because the offense was completed before the attempt to withdraw. Let's move on to question number 3. Third time's the charm. Computers Inc. contracted in writing with bank to sell and deliver to bank a mainframe computer using a new type of magnetic memory, then under development but not perfected by computers, at a price substantially lower than that of a similar computer using Current technology. The contract's delivery term was FOB Bank, on or before July 31st. For this question only, assume that computers tendered the computer to Bank on August 15th and that Bank rejected it because of the delay. If computers sues Bank for breach of contract, which of the following facts, if proved, will best support a recovery by computers? A. The delay did not materially harm Bank. B. Computers believed, on the assumption that Bank was getting a super deal for its money, that Bank would not reject because of the late tender of delivery. C. Computers' delay in tender was caused by a trucker's strike. Or D. A usage in the relevant trade allows computer seller a 30-day leeway in a specified time of delivery unless the usage is expressly negated by the contract. Take 10 seconds, choose the best answer. If you chose D, a usage in the relevant trade allows computer sellers a 30-day leeway in a specified time for delivery unless the usage is expressly negated by the contract, you would have been correct. Under the UCC, a usage of trade is any practice or method of dealing having such regularity of observance in the place, vocation, or trade as to justify an expectation that it will be observed with respect to the transaction in question. In this case, computers had contracted to sell and deliver a computer to Bank on or before July 31st, but would actually tendered the computer to Bank on August 15th. Bank rejected it because of the delay. If computers can show a usage of trade that computer sellers have a 30-day leeway for delivery, then Bank would be in breach for rejecting the computer due to this delay. Therefore, the facts that would best support computers' recovery would be if a usage in the relevant trade allows computer sellers a 30-day leeway in a specified time of delivery, unless the usage is expressly negated in the contract, which it doesn't seem to have been here. Let's move on to question number 4. Plaintiff sued defendant for injuries sustained in an automobile collision. During plaintiff's hospital stay, doctor, a staff physician, examined plaintiff's x-rays and said to plaintiff, "You have a fracture of 2 vertebrae, C4 and C5. Intern, who was accompanying doctor on her rounds, immediately wrote the diagnosis on plaintiff's hospital record. At trial, the hospital record's custodian testifies that plaintiff's hospital record was made and kept in the ordinary course of hospital business. The entry reporting doctor's diagnosis is, as a result, A, inadmissible because no foundation has been laid for doctor's competence as an expert. B, inadmissible because doctor's opinion is based upon data that are not in evidence. C, admissible as a statement of then existing physical condition. Or D, admissible as a record of regularly conducted business activity. Take 10 seconds and choose the best answer now. If you chose D, admissible as a record of regularly conducted business activity, you'd be correct. Hearsay is an out-of-court statement offered to prove the matter asserted in the statement. The hearsay exceptions are former testimony exception, present sense impression, present state of mind, statements of past or present mental or physical condition made for the medical diagnosis or treatment, business records exception, public records exception, judgments of previous convictions. Every item of non-testimonial evidence must be authenticated to prove what the proponent of the evidence claims it to be. Self-authenticating documents are certified copies of public documents, acknowledged documents, official publications, newspapers and periodicals, business records, and finally, trade inscriptions. Here, the hospital records custodian testified that plaintiff's hospital's records was made and kept in the ordinary course of the hospital's business. As a business record, it falls under the business record exception for hearsay. Additionally, as a business record, it is a self-authenticating document. Accordingly, the entry reporting doctor's diagnosis is admissible as a record of regularly conducted business activity. Question number 5. Martin, the owner in fee simple of Orchid Acres, mortgaged Orchid Acres to Marie to secure the payment of the loan she made to him. The loan was due at the end of the growing season of the year in which it was made. Martin maintained and operated an orchard on the land, which was his sole source of income. Halfway through the growing season, Martin experienced severe health and personal problems, and as a result, left the state. His whereabouts were unknown. Marie learned that no one was responsible for the cultivation and care of the orchard on Orchard Acres. She undertook to provide, through employees, the care of the orchard and the harvest for the remainder of the growing season. The net profits were applied to the debt secured by the mortgage on Orchard Acres. During the course of the harvest, Paul, a business invitee, was injured by reason of a fault in the equipment used. Under applicable tort case law, the owner of the premises would be liable for Paul's injuries. Paul brought an appropriate action against Marie to recover damages for the injuries suffered, relying on this aspect of tort law. In such lawsuit, judgment should be for A. Paul, if, but only if, the state is a title theory state, because in other jurisdictions, a mortgagee has no title interest, but only a lien. B. Paul, because Marie was a mortgagee in possession. C. Marie, because she acted as an agent of the owner only to preserve her security interests. Or D. Marie, if, but only if, the mortgage expressly provided for her taking possession in the event of danger to her security interests. Take 10 seconds now. If you chose B, Paul, because Marie was a mortgagee in possession, you'd be correct. The rule is that when a debtor abandons a property secured by a mortgage, the lender is entitled to take possession of the property and do whatever is necessary to preserve the security interest. However, a mortgagee in possession also assumes all liabilities that arise in the true owner of the property. In this case, the applicable tort case law states that the owner of the premises would be liable for Paul's injuries. So Marie, as the mortgagee in possession, would be treated as a true owner of Orchard Acres, and as such, Marie would be liable to Paul for the damages suffered as an invitee on Orchard Acres. Question number 6. Homeowner owns a house on a lake. Neighbor owns a house across a driveway from homeowner's property. Neighbor's house sits on a hill, and neighbor can see the lake from his living room window. Homeowner and neighbor got into an argument, and homeowner erected a large spotlight on his property that automatically comes on at dusk and goes off at sunrise. The only reason homeowner installed the light was to annoy neighbor. The glare from the light severely detracts from neighbor's window and his view of the lake. In a suit by neighbor against homeowner, will neighbor prevail? A. Yes, because homeowner installed the light solely to annoy neighbor. B. Yes, if and only if neighbor's property value is adversely affected. C. No, because neighbor's view of the lake is not always obstructed. D. No, if the spotlight provides added security to homeowner's property. Take 10 seconds and choose the best option now. If you chose option A, yes, because homeowner installed the light solely to annoy neighbor, you'd be correct. A private nuisance is an unreasonable interference with the plaintiff's use and enjoyment of the land. The interference must be substantial and unreasonable. The defendant's conduct is unreasonable if the harm to plaintiff outweighs the utility of the defendant's conduct, or the harm caused to the plaintiff is greater than the plaintiff should be required to bear without compensation. The defendant's conduct must also be negligent, abnormally dangerous, or intentional. In this case, the facts establish that homeowner intentionally installed the light to annoy neighbor. The interference is substantial because the light's glare severely detracts from neighbor's view of the lake, and this would likely be annoying to an average person. Homeowner's conduct is unreasonable because the harm homeowner is causing neighbor outweighs any utility homeowner has in the large spotlight installed solely to annoy neighbor. Accordingly, neighbor will prevail because homeowner installed the light solely to annoy him. Question number 7. Defendant is charged with murder. The evidence shows that she pointed a gun at victim and pulled the trigger. The gun discharged, killing victim. The gun belonged to victim. Defendant testified that victim told her, and she believed it, that the gun was a stage prop that could fire only blanks, and that she fired the gun as part of rehearsing a play with victim at his house. If the jury believes defendant's testimony and finds that her mistaken belief that the gun was a prop was reasonable, they should find her A. guilty of murder, B. guilty of manslaughter, C. guilty of either murder or manslaughter, or D. not guilty of murder or manslaughter. Take 10 seconds. If you chose option D, not guilty of murder or manslaughter, you'd be correct. Murder is the unlawful killing of a person with malice or forethought. Voluntary manslaughter is an intentional killing that would be murder but for the existence of provocation or self-defense or diminished capacity. Involuntary manslaughter is an unintentional killing that results either from criminal negligence or misdemeanor murder. In this case, defendant was told by the victim, and she believed it, that the gun was a stage prop that could only fire blanks, and that she fired the gun as part of rehearsing a play with victim at his house. As such, defendant cannot be found guilty of murder because she did not act with malice or forethought, i.e., no intention to actually, in fact, kill the victim. Since she has not committed murder, she obviously cannot be found guilty of voluntary manslaughter, because voluntary manslaughter is murder but for the existence of a valid defense. Lastly, defendant cannot be found guilty of involuntary manslaughter either because, while this was clearly an unintentional killing, it was not the result of criminal negligence by the defendant, nor did it occur during the commission of a misdemeanor or unenumerated felony. As a result, D would be the correct answer. Question number 8. Computers Inc. contracted in writing with bank to sell and deliver to bank a mainframe computer using a new type of magnetic memory, then under development but not perfected by computers, at a price substantially lower than that of a similar computer using current technology. The contract's delivery term was FOB Bank on or before July 31st. For this question only, assume the following facts. After making the contract with bank, computers discovered that the new technology it intended to use was unreliable and that no computer manufacturer could yet build a reliable computer using that technology. Computers thereupon notified bank that it was impossible for computers to, or anyone else for that matter, to build the contracted for computer in the present state of the art and the technology. If bank sues computers for failure to perform its computer contract, the court will probably decide the case in favor of A. Computers, because its performance of the contract was objectively impossible. B. Computers, because a contract to build a machine using technology under development imposes only a duty on the builder to use its best efforts to achieve the result contracted for. C. Bank, because the law of impossibility does not apply to merchants under the applicable law. Or D. Bank, because computers assume the risk in the given circumstances that the projected new technology would not work reliably. Take 10 seconds and choose the best option now. If you chose option D, you'd be correct, bank, because computers assume the risk in the given circumstances that the projected new technology would not work reliably. Impracticability is a subjective test that examines whether performance would be commercially reasonable due to subsequent circumstances unforeseeable at the time of contract formation. In this case, Computers Inc. contracted with bank to sell and deliver to bank a mainframe computer using a new type of magnetic memory that was then under development but not yet perfected by computers. Computers clearly assume the risk that this new technology would not work reliably, and as such, if bank sues computers for failure to perform its computer contract, the court would probably decide the case in favor of bank. The next to last, question number 9. Defendant is on trial for participating in a drug sale. The prosecution calls witness, an undercover officer, to testify that when seller sold the drugs to witness, seller introduced defendant to witness as my partner in this, and defendant shook hands with the witness but said nothing. Witness's testimony is A. Inadmissible because there is no evidence that seller was authorized to speak for defendant. B. Inadmissible because the statement of seller is hearsay, not within any exception. C. Admissible as a statement against defendant's penal interest. Or D. Admissible as defendant's adoption of seller's statement. Take 10 seconds and choose the best answer now. If you chose option D, admissible as defendant's adoption of seller's statement, you'd be correct. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay is generally inadmissible. A hearsay exemption is admissible because it is not hearsay under the federal rules of evidence. One such exemption is admission of a party opponent, which is a statement by a party or someone whose statement gets attributed to that party, offered by the party opponent. A vicarious party admission treats the admission as made by the party opponent. One form of vicarious party admission is an adoptive admission, i.e., a non-party makes a statement and a party indicates he believes it to be true, i.e., adopting as their own. Here, the non-party seller made a statement introducing defendant as my partner in this, quote unquote. Defendant shook hands with witness but said nothing. If defendant was not seller's partner, it would have been reasonable for defendant to deny it and not shake witness's hand as if he was seller's partner. Defendant's behavior indicated that he believed seller's statement to be true, so the statement will be treated as if it was made by defendant. Thus, witness's testimony is admissible as defendant's adoption of seller's statement. Our final question for this grouping. Question number 10. Adam owned Blackacre. Adam entered into a written 3-year lease of Blackacre with Bertha. Among other provisions, the lease prohibited Bertha from assigning this lease in whole or in part and from subletting Blackacre in whole or in part. In addition to a house, a barn, and a one-car garage, Blackacre's 30 acres included several fields where first Adam and now Bertha grazed sheep. During the following months, Bertha, 1, by a written agreement, allowed her neighbor Charles exclusive use of the garage for storage under lock and key of his antique Packard automobile for 2 years, charging him $240. And 2, told her neighbor Doris that Doris could use the fields to practice her golf as long as she did not disturb Bertha's sheep. Which, if any, of Bertha's actions constituted a violation of the lease? A, 1 only, B, 2 only, C, both 1 and 2, D, neither 1 nor 2. Take 10 seconds, choose the best answer. If you chose option A, you'd be correct, 1 only. The rule is that a landlord can prohibit the tenant from assigning or subletting her interest without the landlord's prior written consent, but once the landlord consents to one transfers by the tenant, the landlord waives the right to object to any future transfers unless the landlord expressly reserves the right to prohibit future transfers. In this case, Bertha's lease of Blackacre prohibited Bertha from assigning this lease in whole or in part and from subletting Blackacre in whole or in part. As such, number 1 is clearly a violation of the lease, as this would be a sublease of part of the Blackacre. However, as to Section 2, on the other hand, it's merely a license, which would not violate Bertha's lease. As a result, the correct answer would be A, 1 only. Thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and ring the notification bell so you can be updated every time we upload new content. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time. We look forward to working with you and helping you prepare for this exam.